This is David Black. I'm a criminal defense lawyer in Phoenix, Arizona. When people get charged with assault in Arizona, so simple assault is a misdemeanor. Typically, if you've been charged with simple assault, you were either arrested or cited with a misdemeanor. It may or may not be a domestic violence offense. So simple assault, non-domestic violence would be like I got in a bar fight or somebody punched me and they got charged with assault. If it's domestic violence, it involves a domestic relationship like husband, wife, or parent, child. Assault can come in 3 different forms in Arizona. The statute that covers assault is ARS 13-1203. We as lawyers refer to it as A1 assault, A2 assault, and A3 assault. They vary in levels of severity, and they go from causing injury intentionally to just touching somebody with the intent to, insult them. That's literally one of the criminal law definitions there. So these levels of assault can carry anything from a maximum of 30 days in jail to a maximum of 6 months in jail. There's no mandatory minimum penalty in Arizona. The max fine is $2,500 plus surcharges. In my career, I have had people go to jail for simple assault, but it's rare. Most often people, if convicted, are given some sort of fine, maybe anger management class, something like this. And also misdemeanor assault is frequently eligible for diversion in city court. So we're assuming that a client is guilty. Obviously, if a client's not guilty, then we're not going to accept either of these things. But if somebody's guilty, then they're frequently offered diversion. And diversion would be an opportunity to take a class and ultimately have the charge dismissed. And so what you want to do if you're charged with assault is obviously take it seriously. It is the kind of crime that would impact, for example, a fingerprint clearance card. But keep it in perspective. It's a misdemeanor. There is no minimum mandatory sentence. If you're facing an assault charge, here are the things that a lawyer in Phoenix can do for you. So somebody comes to us, they've been charged with assault. We want to know what is the nature of the assault? Was somebody hurt? But we also want to know who is the individual and are there any defenses? The most common defense to an assault charge is justification. And justification can be anything from somebody was trying to trespass and I had a legal right to stop them and put my hands on them, to somebody was trying to hurt me or in fact did hurt me and I had a legal right to hurt them back. And so we want to analyze the case. That's from a legal perspective. We also want to flesh out the facts. We want to talk to people. We want to review video. We want to look at the body-worn cameras, see what the alleged victim said, see if the client said anything that could be used against them. And so once we've established all of that, frequently we're ready for trial. We're going to pitch something to the state and say either state, you got the wrong guy, you need to drop this case, or state, prosecutor, how about you give us diversion or how about you give us some sort of better deal? And if we can come to an agreement, wonderful. If not, we try the case. And then the state has the burden of proving beyond a reasonable doubt 2 things. A, that the assault occurred, and B, that it was unjustified. So they literally have to prove that it was unjustified. We don't have to prove that our client was justified. If you have any questions about this, feel free to call any of the lawyers at our firm. We can be reached at 480-280-8028. Thank you.